Hello everyone, welcome to the webinar, the joint ADMA DGA webinar this afternoon. Thanks for joining us. My name's Murray Hyde. I'm Head of Regulatory Affairs and Compliance at ADMA. I'm also General Manager of the DGA, so I'm striding both organisations today. And we're here to discuss the amendments to the privacy legislation, which have just gone through Parliament. Very exciting thing to be talking about today. And with me I have ADMA CEO Jodie Sangster and partner at Allen's Gavin Smith. Thank you for thanks to both of you for coming.
Pleasure.
Welcome. So I guess probably we need to kick right off and start thinking about what is this about. There's some history to this amendment and to the privacy laws generally. So over to you, Gavin, I guess, to kick us off.
Thank you very much, Murray. So the act that we are talking about, or the bill, is the excitingly titled Privacy Amendment Notifiable Data Breaches Bill 2017. And as many people will know, it has a bit of a tortured and long history. So the history of this goes all the way back to 2008, when the Australian Law Reform Commission published its For Your Information report on privacy, on the privacy landscape in Australia. And as part of that Australian Law Reform Commission report, they recommended that a mandatory data breach notification law should be introduced. So back in 2008. Then under the last Labor government, a bill was proposed, was heard and passed by the House of Representatives, and then was in a form that was ready to go through second reading in the Senate and would have been passed had Kevin Rudd not called an election early, and so the bill lapsed. And at that point, the bill really went into the long grass. There was an attempt by Senator Lisa Singh from Tasmania to resurrect it under the Private Members Bill, which again failed. And fast forward then back to the end of 2014, start of 2015, when the current government decided that it wished to introduce the mandatory data retention rules in relation to the telecommunications industry. And effectively as part of a political deal with Labor and the Greens to get that legislation through on mandatory data retention laws for telcos, the government agreed that it would introduce a mandatory data breach notification law to apply to all businesses in Australia, so not just the telecommunications industry. At the time, a commitment was given to get that into law in 2015, and of course that didn't happen. It also didn't happen in 2016, and here we are now in 2017, almost 10 years after the original LRC report, with finally a law that has been passed into law and has received assent. So that's a bit about the history, and it is tortuous.
Thanks very much for that, Gavin. So I should also point out before we continue that we welcome your questions. We'll do questions right at the end, and but feel free to throw them into us. We've got the fantastic Nicola here from our team, taking a look at the questions as they come in, compiling them. So feel free to leap right in. So I guess the obvious question then, Gavin, is what's the amendment about?
Well, so the amendment to the existing Privacy Act is to introduce a new mandatory data breach notification scheme. And what does that mean? Well, it means that when organisations have reasonable grounds to believe that they've suffered an eligible data breach, and we'll come to each of these terms, then they must notify a number of different organisations or people. Firstly, the Office of the Australian Information Commissioner, the OAIC. Secondly, affected individuals. And then thirdly, a slightly odd category which people can generally forget about, but it's individuals at risk of certain particular matters. But most importantly, it's the OAIC and affected individuals who have been impacted by the data breach. So importantly, it means that you don't have to notify your entire customer base, only affected individuals.
Fantastic. So the obvious question is, when will it become law? It's been through both houses of Parliament a number of times. It's gone for royal assent. So what does that really mean, and when does is it law now, or does it take time?
Yeah, great question, Murray. So it has received royal assent. It received assent on the 22nd of February. The way the Commonwealth legislation works is a slightly peculiar fashion, but it means that it will become law on the date that is 12 months after assent, unless the Minister decides to proclaim it coming into force before then. That does not normally happen. So the expectation here is that this takes effect on the 22nd of February 2018.
Fantastic. Next obvious question is, what are the expected impacts on business? So I guess this is a good time to introduce Jodie and talk about the impacts, Jodie, on Australian business.
So I think Australian business, as Gavin has pointed out, has got a year to prepare itself, so that it is in a position that in a year's time, should a data breach occur that fits within the criteria, which we will go into, that they are in a position to both identify that breach, importantly, then report the breach, be able to identify that the breach actually requires reporting. So that's a second part of it. So have those criteria, work through the criteria, and then say, yes, this is a breach that we believe needs to be reported. It then needs to have the processes, procedures in place that the Privacy Commission and the affected individuals are notified. And then deal with the impact of that. So a lot of this is around process, and I do think it's important to point out at this stage that many businesses are doing this already. So data breach notification is not something brand new that no one's heard about before. Many businesses have been on the front foot and been notifying customers should they have a data breach, and indeed that's the right thing to do for consumer trust. So that has been happening, but it's now maybe for the smaller organisations that perhaps didn't have those procedures in place to look at what framework they need to be operating under, what policies and procedures do they need to put in place so that they can comply with the law in a year's time. There is a really good guide. Actually, the Privacy Commission had a guide anyway, which was, it wasn't mandatory at that time. It was, you could choose to comply with the guideline if you wanted to, but there were some really good directional things in there as to how businesses can cope with this, and that would be well worth looking at now.
Fantastic. Gavin?
And I might just add to that as well that importantly, this new law doesn't impose any new requirements in relation to security measures or technical protections that you need to put in place in relation to personal information that's governed by the Act. That position is still governed by APP 11, Australian Privacy Principle 11, and will continue to be the case. That said, the expectation is that for some organisations, the bringing into force of this Act or this amendment will trigger a renewed focus on what technical measures, security measures that they have in place, given the obligations that will then flow if they suffer a breach.
So, Gavin, can you maybe expand a little bit on how this is different? The new law is different to the current law.
I can, Murray, and well, the starting point is, as Jodie mentioned, that there is currently absolutely no obligation in law to notify either the Office of the Australian Information Commissioner or individuals if you suffer a security breach, a cyber attack of some sort that impacts on personal information of individuals. There is, the Privacy Commissioner has previously, through a sort of backdoor mechanism, sought to impose a pseudo obligation, and he did that by using APP 11, Australian Privacy Principle 11, which is the security measures principle. And what he had said was that he would consider the possibility of an organisation being in breach of APP 11 if it had not taken steps after a security breach to allow individuals to secure their own data and prevent further harm from occurring. It's an interesting approach, and it was never tested, but it was the Privacy Commissioner's way of trying to bring some pressure to bear on organisations. So no express obligation at the moment at all. So this is new, the idea of having a mandatory breach obligation. There are some subtle differences between the best practice guide that Jodie just mentioned and the new Act in the wording, none of which we think are particularly substantive. So there are some changes in wording. For example, it used to refer to the concept of there being a real risk of serious harm, and now the assessment needs to be made as to whether there is a likelihood of an event resulting in serious harm. And so there are some semantics, but that really is a sort of one for the legal purists.
Many of whom haven't tuned in today. Thank you, Gav. There's a question, actually keep your questions coming in. There's a question here, and I know I said we'd do it at the end, but I think it's probably relevant to pick this up now. There's a question for Jodie from Darshil. And the question is it mandatory to get criteria to identify breach verified or agreed or endorsed by the government?
That's a bit of a confusing question. I think what the question is asking is, what is the criteria that we need to take into account to consider whether or not we have to go and report that breach, or whether we can consider that breach doesn't need reporting. So where is that criteria? The criteria doesn't really exist at the moment, and this is I guess one of the challenges with the new legislation. So as Gavin has mentioned, the test that we need to apply to say, yes, we need to go out and notify both the Privacy Commissioner and consumers that this breach has taken place, is whether there's the likelihood that a breach has occurred, and that is likely to result in serious harm. So you've kind of got this likelihood test, and then you've got the serious harm test. And both of those are quite grey concepts at the moment as to, well, when is it likely that that's happened, and how do I know that the harm is going to be a serious harm? And look, we can put some criteria around it now, and we'll talk about that a little bit more, but that will be somewhere that both DGA and ADMA will step in to create a joint guideline to say, okay, this is how you assess likelihood, and this is how you need to assess serious harm, and we will work on that criteria over the next couple of months to make sure that industry has some sort of guideline to work to, and to make that job a little bit easier.
Okay. That actually segues nicely into that next question, which is every breach reportable? So, Gav?
Yeah, so the good news is that not every single breach is automatically reportable, as Jodie was mentioning. So breaches are only reportable where there are reasonable grounds to believe that there has been what is called an eligible data breach. If there aren't reasonable grounds to believe that that an eligible data breach has occurred, then you don't need to report. You may still want to think about what has occurred and what steps you might be taking. It's not to say that therefore that then wipes those issues off the slate, things that are not eligible data breaches. But that is the critical threshold question. And the existing OAIC's guide is a really good place to start, actually, for guidance on making that decision. So it's a very useful resource, and we recommend in the first instance at least that is, along with guidelines that the DGA and ADMA will jointly release, is a good place to start.
Fantastic, thank you. We've got another question come in from Alan. Is there a prescribed template that organisations can use to ensure our notifications are compliant, or as compliant as possible in the event a determination of the breach is reportable?
Not yet. But this is again something that both DJ and ADMA can help with. I think at this stage, if you do have a breach, this is really where both an internal compliance team and also a kind of a marketing / kind of customer experience team can work together to come up with a communication that goes out to the consumer, that doesn't put the fear of God into them, but at the same time provides information about what's happened in a consumer friendly way, and provides guidance on the steps that an individual can take to protect their data. So I actually do think that if this happens, it's a good opportunity for a company to take on that kind of role of, we're here to help you. Data breaches, unfortunately, are a reality for every business in Australia, because we are, every company is at at risk of a cyber attack. So it's really to be prepared to present a notification to people that they can understand, that is not fear-mongering, and really kind of delivers back to helping the consumer to take those next steps.
Fantastic. There's another question's coming. Can we provide some examples of a data breach that needs to be reported? Now, it's funny, I look to my left here in the room and Gavin's there. However, I've just realised on the screen it looks like I'm calling Jodie Gavin. So let's not do that. So, but Gavin, that question, can we provide some examples of a data breach that needs to be reported?
Yeah, and that of course is the $64 million question, or perhaps I should say the $1.8 billion question.
That's right.
But perhaps the way to answer that is to first just run people through what the definition of the eligible data breach is. So this is the critical part of the Act. It is the nature of the breach which will be subject to this reporting obligation. So an eligible data breach is, and I'm going to read this because I think it's important to get the full flavour of it. It's an unauthorised access to or unauthorised disclosure of information which a reasonable person would conclude would be likely to result in serious harm to any of the affected individuals. Or, so that's the first part. Or the second part, a loss of information, in circumstances which are likely to result in unauthorised access to or unauthorised disclosure of the information. And if that disclosure were to occur, again, a reasonable person would conclude that the access or disclosure would be likely to result in serious harm. A lot of words in there. The key things are unauthorised access to or unauthorised disclosure of, or a loss of information. And a reasonable person would conclude that it is likely to result in serious harm to any of the affected individuals. And there are a number of limbs there, and obviously then the question is, what are practical examples of that? So there are some obvious ones. So if you hold a database of medical records of individuals, that database is hacked in some shape or form, and you know someone has been able to extract the medical records on an identified basis about individuals. Clearly, the risk of harm arising from individuals is significant. Similarly, financial information. Clearly, the risk of harm is serious. And so that is absolutely the sort of breach that you would need to notify. Where it gets much harder is where you have attacks which result in less obviously impactful information being extracted or taken. So, for example, email addresses or home addresses. That sort of thing. And there you will have to then make a judgment call on whether those things are likely to result in serious harm given the circumstances of the situation.
Yeah, I think that's exactly right, and something that may look like a data set that doesn't have a real risk of harm actually could do if it's matched up with other data, etc. So it does need to be thought through, and maybe it's not just a simple equation to say, well, it's only email addresses, so therefore we don't think there's a real risk of serious harm. It's looking at that and who has hacked that, how that data could potentially be used and what it potentially could be put together with, and the impact of that. So there does need to be a little bit of thought that goes into determining whether that breach needs to be reported or not.
And I should also just add that the position up until now under the best practice guide and the view of the Commissioner has been to set a relatively low bar on that. So take email addresses as an example, could potentially be innocuous, but of course email addresses are traded, they have a currency, largely used for phishing attacks. The potential for phishing attacks is considered to be a risk of harm, and in some cases, if you know that it has been taken by hackers who could then use those to the detriment of individuals, then that probably would end up being the sort of breach that you would notify.
I think the other one is passwords that often comes up. A password by itself, no, not that risky, but actually if you apply that and look at the consequences of that, could potentially lead to a risk of serious harm. So yeah, it's not a simple process to go through to determine whether you sit within the realms of the legislation and need to report or not. So this is going to be a challenge for business.
Right. Okay. So the questions keep coming in. Thanks, everybody. Tim G has asked us, what's the time frame for some of the examples of the data breach? What time frame do they need to be reported? So, Gavin.
Yeah. So the timeframes are interesting. So what the amendment does is it allows a period of 30 days for companies to determine whether there has been an eligible breach. Once you have determined that there is an eligible breach, then you must notify individuals promptly. Now that's an interesting time frame, because actually it allows an organisation quite a long time to reach that determination. However, if you have reached a determination that it's an eligible breach, i.e. it's one that's going to cause serious harm to individuals, and you know that straight away, then that doesn't mean you can then sit on your hands for the remainder of the 30-day window and formally make a determination that it is one at the end of that 30-day window. So you're going to have to then act as soon as you are very clear what it is. But it does allow a window for you to conduct the investigations. That might mean forensic investigations into your IT system to establish exactly what sort of data has been impacted, and so on. Those are the timeframes.
Am I right, Gavin, in thinking that there's part of the legislation is it talks about suspicion of breach, not just a confirmed eligible breach?
Yes. Yeah, that's absolutely right. So the way it works is that if you have a suspicion of breach, then you're under an obligation to conduct investigations to establish whether it is an eligible breach, i.e. one that will cause serious harm. And so that then triggers your 30-day window. But in most cases, companies will know. In some cases, you become aware that something has happened actually long time after the issue initially arose, because it's been buried in your IT system somewhere. You only discover that someone had been extracting data back in December of last year or something like that at a particular point when you're checking logs. It's when you then have that suspicion that something might have occurred that then triggers your 30-day window to make the determination.
Right. There's another question that's come in from Ron, and it's a question about if data is lost/hacked and it's encrypted, does that still need to be reported?
Well, I think it comes down to, it comes back to the same test really. So if that encryption, if you truly believe that encryption, is going to protect the data and that there is no risk of serious harm because it is encrypted, then you could, as a business, make the determination to say, well, we actually don't think there's a risk here, so we don't need to report it.
Right.
So it kind of goes into the mix of the test and the criteria that you need to apply to determine whether a real or a risk of serious harm exists.
Okay.
But bear in mind that encryption technologies change. Just because data is encrypted doesn't mean that it necessarily is entirely foolproof. So, back in 2010, everyone used MD5 hashing technology on passwords. It is well known now that MD5 is compromised, and so just because it's using MD5, that doesn't mean that you can guarantee that that it is secure. So, it is an assessment about the particular circumstances of the case. What sort of encryption has been used? Is that encryption still strong in market, so it hasn't been hacked itself? And if you form that view that it is still strong, then you would not be in a circumstance here where you have an eligible breach.
Yeah, that's right. One of the things we haven't talked about as part of this, and when we talked about how the law has changed, is that we've moved from kind of a self-regulatory process to now regulatory, and it does have fines attached to if you breach the legislation and you get this wrong, and the fines are substantial. So this does also need to be taken into account when you're looking at, do I need to report this or do I not? In some instances, I think businesses may err on the side of caution and perhaps notify the Privacy Commissioner and consumers in circumstances where they're just not sure, to make sure that they are not found on the wrong side of the law. So the fines, and Gavin alluded to it, but it's $1.8 million per infringement. So
that's for companies, right?
That's right. I mean, and that's a maximum. Let's not overstate this. That's an absolute maximum, and the likelihood of being pinged with 1.8 million is relatively small.
But that's not a guarantee, boss.
But there are fines attached to it now, which I think both brings it to the fore in terms of risk for business, and does mean that this whole idea of being able to assess what has happened with that data, what is the risk of harm, etc. It really does focus the efforts much more.
There's also a fine for individuals too, with a maximum of $360,000. So for anybody who's planning to do something egregious, don't. It's our hearty advice. I'd like to ask about the threshold test. What is the threshold test with regard to this new legislation, Gavin?
Yeah, so the threshold test, I think, just to sort of restate really what we've been talking about, is to determine whether there are reasonable grounds to believe that an eligible data breach has occurred. So that is the decision that any organisation will need to make when they know that there is some sort of security issue or there has been some sort of mishandling of data. Worth mentioning, I think, at this stage, that we always focus on cyber attacks when we talk about this.
Yeah.
Actually, if you look at the stats, still very large proportions of data breaches are arising out of human error from individuals in organisations, and we all know the sort of thing that can happen when a file containing information is sent to the wrong recipient, a setting on an open web page is left open rather than secured, that sort of thing. Human error is still a core part of this, and so all of those issues as well are relevant to this, are fully within scope for this new piece of legislation. So threshold test, reasonable grounds to believe that an eligible data breach has occurred, eligible data breach being one which would result in serious harm to any of the affected individuals.
So we've got another question, and I will also remind everybody that for those of you who are out there furiously scribbling notes, we'll have the full video of this webinar and a podcast up on the both ADMA and DGA websites next week. So nothing like setting ourselves a deadline, so that's a deadline. And you'll be able to play this back at your leisure and really be able to dig into the meat of it. So the obvious question around eligible data breach, and it, is determined by whether it will create serious harm, cause serious harm. Is anyone exempt? Gavin?
So as many people will know, there is an exemption in the Privacy Act already for small businesses. Small businesses defined as businesses with a annual turnover of less than $3 million. So this this provision that has been added into the Privacy Act is still subject to that exception. So the small business exception applies, which is good news for small business. However, a note of caution. Obviously, handling personal information comes with major reputational damage potential, and so if you're a small business, if you suffer a security breach, we are not saying to you it's fine, don't report. On the contrary, you will still need to make an assessment as to whether you should report it to individuals or the commissioner, because if you don't, there is the peril of potentially being dragged through the press, reputational damage, trust issues. So that's a category of people or companies who are accepted. Happily, there's also another exception in the Act, which is quite important, and that is that if you suffer an eligible breach, but you then rectify it, so you remediate that, such that there is no likelihood of serious harm occurring or ongoing, then that then takes you out of the regime. And the sort of thing we're talking about here are where, for example, a file containing personal information is sent to the wrong recipient. You get in touch with that recipient and you say to them, it was sent to you in error, delete it from your systems on a permanent basis and confirm to us that that has happened and that it has not been passed on to anyone else and will not be accessed by anyone else. If you take those steps, then if you think about it really practically, there is no likelihood of serious harm to occur to individuals, and therefore it's not a breach that you would have to notify to the individuals or to the Privacy Commissioner. Other examples are where you might identify that there is a security flaw in your system, but you close it and you are able to prove that there was no extraction of data or access to data during the period that the security flaw existed. Again, then you would be able to say that you've taken remedial action and therefore it's not an eligible breach that needs to be notified. So that's an important exemption portion of the Act.
Another couple of questions that have just come in online. Just harking back, Jody, to the fines. I think we've scared Nancy, who's asked the questions: are the fines per breach or per customer affected?
So the wording is per infringement, and it's not always clear as to how that's defined. So it could be defined as per incident, or it could be defined as per individual. I think it's unlikely to be defined as per individual, as obviously the fines can get to the point of excessive. But there is, I can't actually give a definitive answer on that because it's not defined.
Yeah.
What we can say is that Timothy Pilgrim, the current information commissioner, has given verbal assurances that he doesn't consider that fines should apply on an individual record basis or an individual or a per individual basis. But that's not to say that you might not have multiple infringements arising out of a single root cause, if you will. So, for example, you might have a breach scenario because you had failed to take proper steps to secure your systems. That could be a breach of APP11. You might then fail to take the steps to notify individuals so that the individuals can then protect themselves going forward. And that could potentially itself then be a breach of the new requirement to notify. And so in that scenario, potentially you have two infringements which theoretically might add up therefore to $3.6 million. On the $1.8 million, the Commissioner got that power in 2014 and he still hasn't used it. So he has not sought a pecuniary penalty from any company yet. What he's actually more keen on doing is seeking undertakings rather than imposing pecuniary penalties. But that said, I always think about the old Mark Twain quote, which is that to a man with a hammer, everything looks like a nail. You have to think at some stage he will try to use the pecuniary penalties power and use a particularly egregious example as a test case for use of the power.
We've got another question from Liana, who's asking, will there be a register of these reported breaches available for online access for the purposes of identifying businesses who have breached or understanding the types of breaches that have occurred? Who wants to take that one on?
So I believe, and actually I'm going to defer to Gavin on this one, but I believe that if there is an undertaking, then obviously that's public. So if it has gone down the path of the Privacy Commission is not satisfied with the way that that has been handled and has requested that that company or enter into undertakings as to what's happened and what they're going to do to solve it, that is publicly available. So that, and then that's part of the deterrent, I guess, that is publicly available. I don't know of any register that they're planning over and above that, unless you do, Gavin.
No, I'm not aware of that, and I think certainly not a public register. So the OAIC does report at the moment on the number of its voluntary notifications. It just reports on the numbers, not on the details. The other organisation that keeps a register is CERT, which is the government's effectively cyber investigation body. They keep a register too, but only of the things that have come to their attention. I'm not aware of any register that will be kept and certainly not made available publicly. What will happen though is that if the Commissioner commences an investigation, and if the Commissioner then issues a report or a determination into a security breach issue that might be a Privacy Act problem, then those documents, so the reports, the determinations, and as Jodie said, the undertakings that might come out of that would then be published. And so that could lead to also further reputational harm.
Absolutely. And I think that whole reputational harm thing is really important here. So this is not just about a new piece of legislation that's come in that's going to impose kind of a compliance burden on business. Because really, this issue, whether or not there was a piece of legislation there, for businesses to be focused on what they're going to do if they do have a data breach and how they go about handling that is something we should be doing anyway. Because as much as there may be a financial penalty on businesses, the real damage here is to reputation. And we've seen businesses go under because of the impact of a data breach on them, and more recently we've seen the stock price of companies come down substantially if you have a data breach. So I don't think this is just about legislation. It's now about saying, well, okay, yes, the legislation will push this to the top of the agenda. It will also kind of make sure that boards and senior management sit up and take notice around this, but it is something we should be doing anyway. And how we go about dealing with that within an organisation, I really recommend that somebody in the organisation takes on responsibility for understanding what this requires, looking at the business and where the risks may sit, for identifying processes and procedures that need to be put in place, etc. So somebody at least is constantly focused on this and can make sure that the business is in a great position to respond should a data breach occur, whether it be from a legislative point of view or whether it be from a reputational point of view.
Another question has come in from Chris in Melbourne. Hello, Chris. And it's a little curly, so I'll just go through it. If a third-party service provider becomes aware and cause of an eligible breach, who then is responsible for notifying the Office of the Information Commission and the impacted individuals, and who wears the penalty in the event for failing to report the breach? Who wants to take that one, Gavin? That sounds like your department.
Yeah, that may come to me. Chris, what a fantastic question. It actually,
we now have to extend the whole event by 2 hours.
Yeah, it goes to the heart of actually some of the really important elements of the Privacy Act. So the way the new regime works is it applies to entities which hold personal information. And depending on how a third-party service provider arrangement is set up, the third-party service provider may either hold the information or it may not. And I'll give you a couple of examples. So if you use a cloud service provider, let's say you use AWS or Microsoft Azure or something like that, then it's generally taken to be the position that the AWS and Azure don't have control over the personal information of companies who have stored their information in the cloud. They don't access that information. Often it's encrypted, and so AWS or Azure in those sorts of cases would not be responsible for a breach of the personal information, because in most cases they would never know what the data was at all. But if you use an external service provider, for example, to be running, say, a payroll or something along those lines, where they're actually handling personal information and they're doing other things with the personal information, then it's likely that that third-party service provider would be found to have control of the information, would be using that information, holding it, and therefore the regime would apply to that third party. So then the question is, who's responsible? And actually the answer in many cases may be both. So where a third-party service provider does hold the information for the purposes of the Privacy Act, then they would have to make a notification, but you would want your contract with the third-party service provider to deal with how that will happen. Because what you don't want is a service provider contacting individuals. You want to have that contact because they are your customers and you're the one who wants to engage with them and manage the flow of communications with them. So it will be part contractual, part an analysis of the nature of the holding and use of the personal information, and then out of that you will then work out who will notify the individuals. In terms of notifying the Office of the Australian Information Commissioner, again, same thing, that will be determined by both the contract and whether the entity holds and uses.
Yeah, such an important question though, because I can guarantee that very few people actually check the service provider contract at the moment to say, where does this responsibility lie? Or have thought through, okay, if this occurs, who's going to do what, etc., etc. So I just, that's a brilliant question and well answered. The other part of that though, Gavin, am I right in thinking that if you have an overseas third-party provider, that it is not possible to push liability onto the third-party provider anymore? So if you are, and particularly this may affect cloud services, that if you are contracting with an overseas provider, that regardless of whose fault it was, the penalties sit with the company sitting here in Australia.
Yeah, that's absolutely right. So there's a rather curly part of the Australian Privacy Principles in the Australian Privacy Principle 8, which deals with offshore disclosure of information. And depending on how and where you have disclosed the information to and to whom, in all likelihood, the way the Act works is that you will have deemed liability for any breach that happens offshore. And so if you sent it offshore, and let's say you sent it to an outsourcing company in another jurisdiction, and there's a breach there, then the Privacy Commissioner can hold you liable for that offshore breach. So that's very important to keep in mind. And I think what that does is it brings us back to, and as a lawyer I would say this, but it brings us back to a core important part of all of this, which is that you will need to relook at your service provider contracts, which govern arrangements for the handling and transfer of personal information, and look to see whether they do the right thing in terms of making sure you have control of communications, firstly, and secondly, that you've got indemnities in place and protections in place so that you can claim against your service provider if they are responsible for some sort of breach.
Wow, that was a great question, Chris. Thanks very much. On that theme, there's a similar question that's come in from Alan, and the question is about the size of companies that fall under the $3 million threshold. And the question is, what if the data breach has occurred in a company that generates less than $3 million revenue per annum, but is a subsidiary of a larger organisation or a group of companies where the parent company's turnover is much higher than $3 million? Is it then reportable by the smaller company? Is there an obligation on the part of the smaller company?
Yes, in short. So yes, in short, the small business exception does not allow big companies to set up subsidiaries that hold all the personal information of their customers and nothing more in a database, and then say that it has no turnover or very little turnover, and therefore there's no need to notify. So the short answer is no, and there's a longer legal answer which I'll leave for another time.
Thank you, Gavin. So there's a question from Storm, who's, to extend from Chris's question, if the third party is an agency, digital or media, and they identify the issue or are the cause, what's the responsibility there?
I think it's the same as Gavin has already pointed out. So I think it depends on who's holding the data, first of all, truly holding the data, and what arrangements the parties have come to through the contract. So this is why it's so important to have whether it's your agency or your service provider contracts, review them and clearly work through the process as to who is going to be responsible should a breach occur, who is going to be responsible for which aspects, so who's going to do what. So it is exactly the same as the position with a service provider.
Okay. We also have another question, which is, if CERT advises that something is hacked, what actions are to be taken to rectify? Now, is it CERT who would notify?
Yeah, so very occasionally CERT might, or it could be the Australian Federal Police, or occasionally, depending on what industry you're in, you may have the pleasure of being visited by particular government agencies who have involvement in this sphere. If that happens, then clearly you have to take that very seriously. So any of those organisations contact you to say that they think there's a possibility you may be subject to some form of breach, or they have grounds to think that they might. And the reason for that is that you would then automatically be found or held to have a suspicion that an eligible breach may have occurred, and therefore that then triggers your obligation to investigate that further. So, so if you have that sort of notification come to you in one shape or another, then you have to act on it, and you should treat that as then you being in this process of assessing whether there has been serious harm, and therefore whether you have to notify.
So one of the questions that's come up from a number of sources has been this one, which is, won't this just cost my business in terms of compliance? Won't this just be a burden on us?
Well, look, yes, there is a compliance cost, yes, but as we kind of stated before, this is an issue that business should be looking at anyway, and you can view this in two ways. You can go, oh goodness, for me, I've got a compliance cost on my business, or actually, I need to be looking at this because consumer trust is going to be so incredibly important moving into the future that it's something I should be investing in, and I actually believe it's the latter. So even if this law didn't come in, now is the time that businesses do need to be investing in making sure that they have the systems, processes in place that deal with these issues, but also address the issue of consumer trust moving forward. So if we're looking at a business differentiator in future, consumer trust is going to be one of them, and the more businesses can proactively show that they are doing the right things with data, that consumers should trust them, and that they can adequately deal with these things, the better it is for the brand. So I don't think it should just be viewed as a compliance cost.
No, it makes no sense to look at it in that respect, does it? Really. We have another question, and we are coming towards the end, so thank you for sticking with us, everybody. I see we've had almost no one drop off, which is marvellous. And let me just find this question again.
How do you report to the Privacy Commission? I thought that was a great question because I've actually got no idea how you go about it. So, Gavin, have you got any idea?
Yeah, I've had the great pleasure of notifying the Commissioner on a number of occasions about data security breaches on behalf of clients. So the short answer is it's a very unsophisticated mechanism at the moment. There is an email address which you can send an email to, and then you receive a response back via that email account in something along the lines of 1 to 2 days, generally some sort of holding response. My suspicion is that in advance of this new regime coming into force in 2018, the Commissioner may revamp that method because it is a bit antiquated. So so watch this space.
Fair enough. If you've got any last questions, please let us know, because we're just about to enter the wrap-up phase, I guess. And so it's the OAIC that's going to be the relevant regulator for us for this. So we've talked about how to contact them. We've talked about if you go to their website, which is oaic.gov.au, there's a mountain of information on there. You can also hit up the ADMA website, adma.com.au, and DGA, which is Data Governance Oz, aus.com.au. And that's pretty much it for questions. So, Carla asked, is there going to be a transcript available? Do you know, Carla, honestly, I haven't considered that, so let me come back to you. We will let all the participants know of exactly when the video and the podcast are going to be available. So we'll address the question about a transcript in that email. So thank you for your question. I'll certainly take it on board. And of course, there's a survey we'd love you to fill in at the end of this. So if you could just take a second while you're still online, appreciate you filling that in for us so we can get some feedback. Any last comments from either of my participants? Jodie?
I think what I would say about this is there is a year to get your house in order, so start now and start thinking about it. And this should be seen as a business opportunity, secondly. And thirdly, I know that there are big fines attached to this, which can put the fear of God into business. But really, the approach that is generally taken with this is that the regulator looks at how it can help businesses to comply with legislation. It is not a case where you'll have one breach, do the wrong thing, and suddenly be whacked with an enormous fine.
Yeah.
So it's something to be taken very seriously, but also not something to put the fear of God into businesses. It can be managed, and we've got a year to do that.
And I think also it's largely about consumer trust. Consumer trust is the real big corner piece, isn't it? Around that. Kevin?
Yeah, just to echo that, you have some time to get your house in order. That is absolutely right. Although, to be frank, you ought to be doing the right thing and doing it well already at the moment. And the reason for that is that if you don't, it goes to consumer trust. The press will potentially haul you over the coals. And if you don't get this right, if you muck up the way in which you notify customers, there is the possibility that you create confusion, you break down the trust that you have spent a long time building in your brand and your services and your products. So getting this right is important, because getting it wrong could have just as deleterious an impact on the trust and the customer relationship as, in fact, the breach itself might have done. So that, I think, is very good reason to spend some time and some focus from people in your organisation to get yourself ready to go with this as earlier than in the next 12 months.
Thanks very much, Gavin. So thank you to everybody for participating. We have the survey, of course. If you've got any questions, if you think of anything that you want to ask post this, feel free to email me at regulatory@adma.com.au, and we will certainly do our best to answer your questions. And thank you to both my participants, Jodie and Gavin, and despite the fact that I keep looking at a photo of Jodie on screen, while I look at Gavin. So thank you all for your participation. Please fill in the survey, and thanks very much. We'll see you again soon.